There's no minutes today, right? Good morning. This is Albert Chang, Chair of the New Mexico Oil Conservation Commission, noting the time just after 9 o'clock on June 3rd of 2026. I hereby call the meeting to order. Commission Clerk, may I please have the roll to confirm attendance?
Yes. Commissioner Bloom,
Present.
Commission Chair Chang,
Present.
Commissioner Mpoma.
Present.
Okay, we have a quorum.
There is an agenda before us, Commissioners. Is there any debate on the agenda?
Mr. Chair, I would move to approve the final agenda.
Mr. Chair, I'll second.
Any objections from Commissioners? Without objection, so adopted. There are no minutes to approve today, as far as I understand, so we will move on to case number 24683, the WELC application for rulemaking to amend NMAC 1915-2, 1915-2, 1915-5, 1915-8, 1915-9, and 1915-25. Is there any matters that we need to resolve before we dive straight into deliberations?
Mr. Chair, I believe we have before us a motion to exclude NMOGA's closing exhibit 7. Probably need to back up actually to look at the prior motions. 1 minute.
There was a motion.
So, Mr. Chair, Dr. Mpoma, we had the applicant's motion to exclude NMOGA's closing exhibit 7 and related finding of facts. That was on May 6th. Then
you have the link to that Commission Clerk shared with us most recently?
Yeah.
You know those folders, and let me see if maybe they're subfoldered. Nope. Nope. Wait, go back to that. Go back to the previous folders. No, that's the HBD. That's the negative. If you want to pull up OCD imaging. To the Commissioner Bloom, can you remind me the dates of those 3 filings, and then maybe you can pull them up on OCD imaging?
yes, Mr. Chair, these were some of the first, some of the last documents filed with respect to this hearing. It was May 6, 2026. That is when the applicants filed a motion to exclude NMOGA's closing exhibit 7 and related findings of fact. That's about a 1.5 page motion. And then the NMOGA and IPNM filed on May 21st, the joint response to the applicant's motion to exclude, a 30-page document.
And there was a reply on June 1st, is that correct?
Reply on June 1st. It's about 7 pages.
Yeah, the last reply was on June 1st. Okay. Do we want to maybe put a pin in this motion until lunch so that Commissioner Mpoma has a chance to review the last reply before?
Mr. Chair, I would agree with that. We could hold this until after lunch.
Great. No problem. Just a second. Sure. Commission Counsel, We're operating, I think, without our hearing officer today until a little bit later. Do you have any advice as to how we would like to proceed? Would we have the hearing officer's report? If you would you recommend following that report as a guide for organizing discussions, deliberations today?
Mr. Chair, the hearing officer and sister environmental agency rulemakings has prepared a hearing officer's report with series of overarching questions, which he has done for this one as well. Some of your sister agencies have gone through the questions, had a high-level discussion, and at that point may have realized that the applicant has met their burden or has not. And so you have a series of options, but that's what your sister agencies have done. So on page 2 of the hearing officer's report, it says major questions, number 1. So one option is to start right there and have a debate over that major question, number 1.
Okay. Commissioners, would you like to go in the order as presented in the hearing officer's report? Or would you like to follow that's fine by me if that's.
Mr. Chair, I think that would be a fine way to proceed to make sure that we work through and have a discussion of all those points and questions and concerns that are raised. And I would be prepared to do that. Then perhaps after we could turn to the joint stipulated rule that we have now in front of us and perhaps go through that section by section.
Works for me. Okay,
No, works for me too. Thank you.
great. In that case, let's start with the first major question that our hearing officer has teed up for us, which is the commission's statutory authority. Commissioners, have you had a chance to review the disputed section here under 7214A NMSA? This is the same provision
Mr.
that we
Chair.
discussed under the original motion to dismiss.
Yes.
Okay. Any thoughts on the dispute between the applicants? And I'll invite any debate at this point.
If I will start. So, Mr. Chair, I reviewed the 70-2-14 requirements for financial assurance. And in there are a couple of items that you can highlight and link that to the application and see whether we follow through on that or not. So I'll highlight a few of them. So I'm reading the Oil Conservation Division established categories of financial assurance after notice and hearing, which I believe that is correct too. From my own opinion, it happened. Such categories shall include a blanket plug-in financial assurance, which shall be set by rules in an amount not to exceed $250,000. And I believe that is what the blanket bond that was presented to us was, $250,000. So that one too, we followed through on that. A blanket bonding assurance for temporarily abandoned status wells, which shall be set by rules and amounts greater than $50,000. That is what we did too, or that is what has been presented to us. One well plug-in financial assurance in amounts determined sufficient to reasonably pay the cost of plugging the wells covered by the financial assurance. And through the hearing, there were a lot of discussions on this matter. The applicant presented their case with OCD, presenting evidence as to how much it cost OCD to plug their wells. And they used that number to actually more or less move forward with the application. Now, NIMOGA also presented their evidence and IPNM presented the evidence. So I believe that we also met that burden as well. And the last one that I'll point out is shall consider the depth of the well involved, the length of the time since the well was produced, the cost of the plug-in similar wells, and such other factors as the Oil Conservation Division deems relevant. And I will say that this matter was discussed extensively. OCD and the applicant showed the commission with evidence that they've considered all these factors. And still they believe that some of these factors, even though relevant, but do not really amount to the cost, that caused OCD to really plug their wells. So I believe that all the stipulations in this rule more or less were discussed extensively, and I therefore believe that the commission do have the authority to more or less proceed to deliberate on this matter. Thank you.
Commissioner Bloom, any comments?
Yes, Mr. Chair, thank you. Sheila, I sent you so the 7214. If we could pull that up, I'd appreciate it if we could make that visible on the screen for folks. As you'll see, I made a couple modifications here to that, which my comments will address. Where to begin? I think in a moment we'll have a chance to talk about, we should talk about, because the question's been raised, does the OCC have the authority to do this sort of rulemaking under, is it under our jurisdiction? Is this related to prevention of waste, protection of correlative rights, and protection of public health and the environment? But I'll set that aside for a moment. And when we look at 7214, I read this as, and I think we heard evidence for, that the statute in the Oil and Gas Act allows for the creation of new types of bonds. You can see here, the language today reads, the Oil Conservation Division shall establish categories of financial assurance after notice and hearing. The legislation, the law does not say the Oil Conservation Division shall establish 3 categories of financial assurance. It could have said that. It does not. Goes on, such categories shall include a blanket plugging financial assurance. It does not say such categories shall only include a blanket plugging financial assurance. So again, I believe that there's room for the creation of new bond categories, financial assurances under 70-2-14. Going down to the next sentence, we see the language in establishing categories of financial assurance. So Conservation Division shall consider the depth of the well involved, et cetera, et cetera. It does not again say in establishing these 3 categories. So again, this is open and new categories can be established. Looking again at that same sentence, it says when establishing categories of financial assurance, the division shall consider the depth of the well, length of time. That's for the category. It doesn't not necessarily mean that it's the well. And I think that the applicants have shown between the environmental groups and the Oil Conservation Division that they were looking at in the creation of this category factors such as length of time, what wells cost to plug. We heard $163,000, but it's been rounded down to $150,000 per well to plug and reclaim the land around it, the site, on average, and other such factors as well. So I believe looking at 7214, clearly there is an opportunity here for the OCC to hear rulemaking on and to create new categories of financial assurances.
Thank you. For my part, I agree. Thank you for pulling this up here. I think this demonstrative is helpful. I'll note for the record here that just for clarity, that the words that are highlighted and with the strike through there were your additions to illustrate that those words aren't in fact there, right? The first sentence of the statute says that the Oil Conservation Division shall establish categories of financial assurance. And then it proceeds to tell us what we must include, shall include the following categories, but it doesn't limit. And in fact, if those 3 were the only ones intended, I'm not sure why the statute would tell us to establish categories of financial assurance if the only categories that it contemplated was already listed in the statute itself. And furthermore, I concede that the next sentence is a bit of a run-on sentence and could be confusing. But you know, no amount of highlighting in various colors is going to change the plain reading, the plain language as I see it, at least. You've got various categories. At no point does the statute say that these categories are mutually exclusive, that somehow the commission or the division couldn't somehow require all three types of bonds, or that any one of them is a cap on the other. So I think all three of us are saying the same thing. So in that case, I will, if we are all in agreement, certainly I'll entertain further debate and comment if there's any, but if we're all in agreement, I think I would entertain a motion to vote in the affirmative, to vote a motion answering this first major question in the affirmative, that NMSA 70-2-14 does provide the statutory basis for the application as presented by the applicant, at least in the final version.
And Mr. Chandler, question for you. Would this typically be something we vote on?
So, Mr. Chair, I'm here to provide a series of options. So that this is one option if you're trying to build a record to tell the court that you've reached a conclusion on this. You don't necessarily have to have a motion right now on this, but it is an option if you want to build the record that way.
Mr. Chair, I would be glad to do so if given that answer.
Is that, I'll take that as your motion then?
So that's my, yes, I move to, I move that the record show that we address this question and believe that new categories of financial assurances can be created given our understanding of 70-2-14.
I second.
Is there any votes in the negative on the commission? Without opposition, it is, let the record reflect that the commission answers that first major question as presented by the hearing officer in the affirmative, that we do have the statutory authority to adopt new categories of rulemaking, and that we do have that this particular statute provides sufficient legal basis for the petition, at least in the as presented in the final draft by the applicants. I will turn to debate on the second question as presented by the hearing officer. Any thoughts or debate on the second issues?
Mr. Chair, I'll go first. So it's about preventing waste. IPNM and NIMOGA said that the proposed amendments will cause premature plugging of wells, resulting in waste of the resource, contrary to section 70-2-2 and 70-2-11 NMSA 1978. Now, on this issue, I also asked a question countering that and say that what about the unplugged wells that are left to leak? You know, those that are leaking, are they also not preventing? Are they not also causing waste? So I do not really agree to this, and I will go further and say that the commission gave the opportunity for the parties to all work together. And if you look at the package that they brought together, to me, it is preventing waste. So, I mean, I do not really assent to this statement that we more or less going forward with this rule will more or less prevent or result in waste. I disagree with that. Thank you.
Commissioner Bloom, any thoughts?
Yes, Mr. Chair. Just give me a second here to prepare my comments. And I should have begun by thanking the parties for this rulemaking and the way it was accomplished. I do appreciate that, and I know that significant time was spent in subsequent negotiations between the parties, and these were done in good faith. And I certainly appreciate this, and we're up here trying to, you know, strike a fine balance between the oil and gas industry and what it provides for our state, and the environmental kind of exposures that are part of it as well. I don't think this is lost on anybody. These are all mandates. All of us deal with this in our regular jobs. That's why we're up here on the Oil Conservation Commission. So this is a weighty subject, and I appreciate the work that you have all put into this. So thank you. All right. Just take a look again at the hearing officer's report. So preventing waste, and when we're talking about preventing waste here, I think what we're really getting at is this an area over which the OCC has jurisdiction? And I believe absolutely that it does, that this rulemaking falls within the statutory jurisdiction of the OCC, given that two of our mandates are to prevent waste and protect public health and the environment. Older wells, and particularly orphan wells, leak methane, which is a waste of the resources, as Dr. Mpoma, who's a oil and gas engineer, just mentioned, a professor of oil and gas. And they also present a threat to human health and the environment. The OCD's closing statement, as was filed April 6, notes over 60% of the orphan wells plugged by OCD cause waste by leaking natural gas. Even wells in approved TA that have met mechanical integrity testing requirements and OCC rules can nonetheless emit and leak natural gas because equipment can fail over time. The applicant's closing argument notes on page 17 that, quote, the U.S. Environmental Protection Agency estimates that an average low or non-producing oil well leaks 1.8 tons of methane into the atmosphere each year, end quote. Mr. Powell of the OCD reminds us on page 16 of the OCD's closing that the legislature also gave the OCD jurisdiction over reclamation. He said, quote, it's also the OCD's job to manage the reclamation fund and to use available fund to plug orphan wells. Goes on to say, quote, OCD also has the obligation to regulate and require the remediation of releases and environmental contamination. So the legislature and law have clearly given the OCC authority over bonding and reclamation. I would more generally cite pages 16 through 20 in the applicant's closing argument. I won't read that entire 5 pages, but I will quote a couple lines. It says, quote, applicants' financial assurance proposals, which increase bonding for high-risk wells and high-risk portfolios, nowhere require an operator to plug a well. Increasing bonding for these wells better reflects the actual costs to OCD, to P&A, and is necessary to stem the tide of orphan wells. If an operator is financially unable to internalize legitimate costs of doing business, the operator can transfer the well to a viable operator who can, end quote. The applicants go on to remind us that wells are routinely plugged in order to be plugged with hydrocarbons still in the ground. It's not economical or even realistic to produce every molecule of hydrocarbon that a well can access. This is discussed in the applicant's closing statement on page 17, where an IPA&M witness admits as much. I believe that was Mr. Rizal saying that, agreeing that we don't get every hydrocarbon molecule out of every well. We should put any waste arguments in context as well, which the applicant's witness, Mr. Purvis, does. For the applicant's closing arguments on page 17, he said, quote, modeled the extent to which wells in New Mexico would be categorized as low-producing wells subject to a single financial assurance. He found 3,900 wells would qualify, representing 6.6% of the statewide well population and only 0.048% of total production, end quote. So about 4,000 wells represent about 7% of the wells in the state. They produce less than 5/100ths of the state's total oil and gas production. Also on this point, I note that the applicant's proposal does not require P&A well, but rather that a class of wells be bonded. Operators can decide when it makes economic sense versus continuing to eke out low production. This should be an easy calculation. I think that was from the applicant's closing argument, actually. Let's see. was quite a bit of discussion too about legislative intent. You know, I would note that this is case 24683, meaning it started in 2024. There've been 2 legislative sessions during that time. Of course, we saw some changes to HB 80, but the legislature could have intervened knowing the outlines and really the particulars of this rulemaking, and we did not see such an intervention. I think I will leave this here for now, Mr. Chair.
Thank you. It sounds like I think I agree with the majority of the sentiments here generally. And I think Dr. Mpoma put it very succinctly that leaking wells are the waste of natural resources that the commission needs to be concerned about here, first and foremost. Wells that cannot be economically, first of all, if a well can be economically produced today, it should continue to be economically produced today. And there's nothing in the rule that would foreclose the continued production of economically viable wells. To the extent that a resource is not today, currently, presently, economically recoverable, preserving it and making sure that it is properly contained and not leaking away to be lost forever, but that perhaps in the future it might be producible, is the definition of the prevention of the waste of the state's natural resources. So I think I agree with the comments of the commissioner that our first priority here is making sure that we don't have abandoned wells that allow the state's natural resources to be dissipated into the environment in a way that will not be recoverable into the future. So with that, I'm happy to invite commissioners if they would like to make a finding on the record that we don't think or that we do think the proposed rule would prevent waste, and we do not concur with the assertion that the rule would cause waste.
Mr. Chair, I'd make that motion, and I would add to that also that I believe that because this rulemaking prevents waste, it also affirms that this is under the jurisdiction of the OCC for this and other reasons as well. Thank you.
I second.
Any opposed? Hearing none opposed, so adopted. Moving on to issue number 3, regulating operator registration and change of operators. Is there I'll invite any debate or thoughts on this provision, or on this question as presented by the hearing officer.
Commissioner Bloom, will you go first? This one is more on on the legal side. So
Sure, Commissioner Mpoma, I will go first on this. Trying to get to my notes on this topic. So on this topic, I believe that the OCC and the OCD have legal authority to regulate registration of operators and change of operators, and indeed have been doing so for some time, if not decades. I believe the OCD's closing statement does a fine job of recognizing it and elaborating on this, but there's one section I would quote on page 9. Quote, the OCC has already exercised this authority. The existing rules authorized OCD to deny operator registrations and change of operator based on an operator's noncompliance. So I am good with that. And then I think we saw ample discussion around the word acquisition, and what's not being stopped is the sale of oil and gas properties from one company to the next, or one operator to the next. Rather, acquisition solely means change of operatorship and should have been, I think, perhaps described in that way. And that may be something we want to address as we go through the rule. I can't remember if that was actually changed over the course of the discussions or in the joint stipulation, but that's something we can look at. But I don't see any conflict there or wider constitutional issues.
I think I agree with Commissioner Bloom's comments here, but to the extent that the word acquisition might be a sticking point for the parties, I'm happy to defer decision on that until we get to the sort of section by section debate. But overall, I think the point that transfer of registration is allowed, and that the intent of the application and of OCD is not to change ownership interest in real property, but to manage the registration of operating authorities. I think I'm happy to take that point, but as to whether the word acquisition, whether there might be a better word in the thesaurus, I'm happy to take that on as not so much a major question, but as a wordsmithing question when we go section by section.
Mr. Chair, I agree with you. I had the same thought that probably I will defer during the discussion of each provisions, and probably we will see if there could be alternative words. But yeah, I agree with you. Thank you.
Okay, well, in that case, we're just going to put a pin in this, and then we'll come back and revisit whether the word acquisition might be better replaced with a different word when we get to the section by section debate. Moving on to.
But Mr. Chair, if you'd permit me.
Oh, please.
Yes. Would you entertain a motion to state that the OCC does believe that we have the authority to make rulemaking that regulates operator registration and change of operator?
Absolutely. If
Then I so move.
I second.
Any opposition? Any votes against? Without opposition, so adopted. In that case, House Bill 80. That's the fourth major question presented by the hearing officer, broken down into three subparts, subpart A, B, and C. We've already had some debate and discussion on this at the last commission hearing, but I'm happy to entertain any further discussions, particularly on whether HB 80 as a matter of policy renders the proposed rule amendments unnecessary, and whether it replaces this rulemaking with a legislative choice.
Mr. Chair, I will start on this one. So when I read through this and looking at House Bill 80, I believe that the House Bill 80 will be complementary to this rulemaking in the sense that it gives OCD more room to plug more wells, let's say within a year, because it is giving them more resources to be able to plug those wells that needs to be plugged. But I don't think House Bill 80 addressed with regards to, let's say, how much does it cost and all of that, you know. So I believe that House Bill 80, just to keep it short, will say that it's complementary to what the rule we are looking at today, but not necessarily making it unnecessary. I see it as more complementary. Thank you.
Commissioner Bloom, any thoughts?
Yes, Mr. Chair, I agree with Commissioner Poma's comments there. Sorry, I'm a little bit off my game here. I didn't know if we were going to begin the day going through the sections, or I was not prepared necessarily to address all these questions in turn, but let's see. The hearing officer asked us, one, does the passage of HB 80 following the hearing require the recalibration of the reasonably pay standard under the Oil and Gas Act due to the differences between OCD's plugging costs and industry's plugging costs? No, and we can discuss this a little bit further, but you know, under questioning, OCD's representative said that OCD and industry costs are apples and oranges. OCD may or may not be able to get the lower prices that industry gets. Clearly, if a company wants to plug wells for the OCD, they have to get on a provider list, via DFA. There's issues involved there. There are more requirements at times. So there's that aspect of it. But I think, more than that, we heard very strongly, and again, based on OCD testimony, I think this is seen in both the applicants and the OCD's closing statements, that wells that are orphaned are more expensive because they've languished for years, if not decades. And when we have cases where, the better operators, the vast majority of operators are going out and plugging their wells appropriately and when they should, and not leaving them. These folks were caring for those wells in an appropriate manner, over a period of decades, not neglecting maintenance, and then not letting the wells, sit for 20 years at a time. When you look at the difference between the wells that industry bonds and the wells that come to the OCD to bond as orphaned, it's definitely going to be more expensive for OCD to bond a well. So on 2, we get the question, or B, I think it might be, does OCD's practice of rarely pursuing financial assurance because collections are minimal and only callable after the expenditure of public funds preclude any commission finding that existing bond levels are inadequate? I think one thing we heard was that bond amounts are so low that calling them is almost discouraged, or something that OCD is perhaps not staffed to get to. Higher bonding amounts would be meant to encourage earlier plugging so that people can be relieved of the bond duties. And then frankly, I think that using public funds or the reclamation funds incentivizes keeping low producing wells active or even inactive for longer periods of time. And then I think it's also a place to mention that HB 80 is also something that could be swept once again. And it would most likely to be swept in a time when there's an oil and gas downturn. I think we heard some conflicting numbers, but I don't think there's any argument that oil and gas provides something between 30 and 50% of the state's budget. Now, if there's an economic downturn, oil and gas is hurt, there's less money for plugging, and that's the same point in time when the LFC, when our legislators have to make the hard choices about sweeping funds. And I remember the last downturn, and people were sweeping, pots of money as little as $10,000, and so we could end up having the reclamation fund with hundreds of millions of dollars in it, and that would be an easy target for a sweep. So as Dr. Mpoma said, I believe that I believe that this rulemaking is important because it's complementary to HB 80 and provides another mechanism to create funds and wherewithal to have proper P&A of oil and gas wells.
Thank you. I think I broadly agree with many of the sentiments from my fellow commissioners here. I agree with it appears to me that the correct assertion is that HB 80 addresses the orphaned wells that are already orphaned today, the wells that are already causing issues that are already abandoned, whereas the application in front of us seeks to prevent the rate, or to slow down the rate at which wells are orphaned, and to prevent this problem from growing into the future. HB 80 does provide significant resources into the reclamation fund. However, I think as some of the briefs pointed out, despite the fact that many legislators were well aware of this rulemaking and that this rulemaking happened both before and after the legislative session, HB 80 is remarkably silent on what the legislature wanted to do with this rulemaking. HB 80 could have inserted the 3 words into 7214A that we discussed under the first major question. They didn't. The legislature did not in any way amend 7214 to say that HB 80 is in some way replacing or changing the categories of financial assurance, despite the fact that at least I don't recall the specific number of legislators who wrote in to express opinions on this rulemaking one way or the other. The legislature had an opportunity if the legislature felt that 7214 was somehow being usurped or being replaced by HB 80. The legislature could have said that. The legislature chose not to. So we certainly want to heed the legislature's intent as closely, at least I do, I'll speak for myself. It's certainly always my intent to heed the legislature's instructions or the legislature's legislation and any act as closely as possible. But in this case, HB 80 legislative could have told us that they made a legislative choice. And I think the plain text of HB 80 and its history shows that the legislature did not, in fact, weigh in on a policy choice as to how they wish to address how these two mechanisms for addressing the abandoned and orphan well problems should interact. And that's why we are back here in the rulemaking space, given the legislative silence. It always makes my job easier when the legislature tells us exactly what they want us to do. So we're not in the difficult position of making these tough choices, but for better or for worse, the legislature, I don't think the legislature weighed in as clearly and as forcefully as perhaps some parties are urging us to believe. On the other questions, I think my fellow commissioners have addressed that fairly carefully. On the question of whether HB 80, so putting aside the question of how we should calculate what the well bonding costs are and whether the cost to OCD alone or whether we should have considered a wider range of costs. I will say that at the last hearing, I repeatedly asked how HB 80 would change the calculus of what the individual well bonding was. I asked whether it would change the age of the wells out there. I asked whether it would change the depth of the wells that are existing. Had certain parties had a party been able to proffer a witness who would make some sort of claim that would link HB 80 to an actual individual well bonding cost, I would have reopened the record and allowed further exploration of that, right? Had a party been able to find evidence or find credible a witness that could have asserted that perhaps due to HB 80's funding, hypothetically, theoretically, could lead to a cost economy of scale that might lead to better contracting rates, that might lead to the OCD being able to get contractors to plug wells at a lower cost, I would have entertained that. Unfortunately, no evidence to that effect or no witness that would have testified to some theory along those lines was presented. And so I'm not seeing a link in the record at this point between how HB 80 would change the cost to OCD or otherwise, how HB 80, there's insufficient information in the record for us to be able to articulate how HB 80 would change the calculus of what the individual cost to bond a well might be. And as for whether or not the plugging costs whether or not the plugging costs that OCD brought to this hearing sufficiently reflects plugging costs across industry. I believe that was something that we had urged the parties to discuss and negotiate. And I don't recall, and perhaps commissioners can refresh my recollection, but if in my recollection of the record, there was very little presentation of what the actual industry's costs are to the extent that they might differ from OCD's plugging costs. And so looking at the totality of the plugging costs evidence in front of us, we'll have to make a decision when we get to section by section as to whether or not the $150,000 proposed in front of us is substantially supported by whatever cost evidence is in front of us through this rulemaking. That's all I have on this particular question. I'll invite any thoughts from other commissioners as to how they would like to, or whether they want to put any specific findings or decisions onto the record for this question, for question number 4.
Mr. Chair, I will add a few points.
Please.
Now, with regards to, let's say, B, OCD discussed the fact that, Commissioner Bloom touched on this, the cost involved to go after, let's say, the bonds. It's not really worth it because the bond is really low. But even having said that, OCD still presented to the commission that they've made progress, in going after some of these bonds. So definitely, even if the bond, I believe that if the bond is increased, that will give them more room to be able to pursue these companies, for the bond amount. And then even the number A, as you said, now Dr. Ascott, who was going to be additional witness from still the same witness, but coming back, if we have reopened the records, we asked IPNM and they said, Dr. Ascott is not going to talk about how the HB 80 impacts the cost to plug a well. So that is why I think we also denied that application because, you are not going to really add anything to the records. And like you said, we will have the opportunity to go through this more detail to see if 150 is appropriate or not. So I will defer any other thoughts on this when we go line by line through the rule. Thank you.
Commissioner Bloom?
Yes, Commissioners, I concur with both of you, and I would move to find that HB 80 is complementary to this rulemaking, but does not substitute for it, and that both are important instruments in addressing orphan wells in New Mexico.
I second.
Motion seconded. Any opposition? Any votes against? Hearing no objections, so adopted. Moving on to, so the next question the hearing officer presented is the joint stipulation, but I'm not sure. I'm not sure that we want. I'm not sure what the question is, other than that we will eventually want to go through it section by section.
Mr. Chair, if you permit me, yes, I think as we get to the bottom of that section 5 of the hearing officer's report, we see the question: should the commission adopt the joint stipulation as submitted, adopt it with alternative language or modifications proposed by industry, or reject it on legal grounds? I think it's exactly what you state, that we'll know once we go through the proposed changes and the joint stipulation, which I suggest we do, go through that line by line, section by section, and vote on it. That we'll then have that answer.
But I do have one question for my fellow commissioners. So if you go to page 7 out of 10, so in last but one paragraph. So OCD agreed to issue formal industry guidance documents on several topics within 6 months of rule promulgation. I just wanted to ask, do we have any action from our side as part of the rulemaking to comment on this?
I wasn't planning on it, and I'm not sure that.
Commissioner Poma, my understanding, I think I've encountered this before over the give or take 9 years maybe 7 years I've been on the OCC. I believe that OCC is agreeing to get those formal guidance documents out quickly so that there can be communication on that and make sure that that's a process that works for everyone. I know when we did the methane waste rule, for example, there were some reporting requirements, and we worked with NMOGA to find a reporting form which could be used by all companies, all operators, that would work for all of them and work for both the OCD and the Mexico State Land Office. So these sorts of agreements are pretty typical. And yes, we need guidance documents as to how these rules that we would create here would be implemented. If that's helpful.
Yeah, so my question was more like, do we just take that as a, let's say, as just a notice to the commission, but we do not have to take any action on that?
I would agree with that, Dr. Mpoma.
Thank you.
Okay, so putting a pin in question number 5 and proceeding to question number 6, is that correct?
Mr. Chair, I think I also want to add that this is the opportunity for me at least to thank all the parties, for working together on this joint stipulation. I mean, it's really, really helpful to see how they all came together, after really dramatic hearing. So, thanks to all the parties for working very hard on this, which makes it much easier for us to really work through this. Thank you.
No, Mr. Chair, as I read through, I guess it's sections 6 through 10 here, what I'm seeing are sort of highlights or summaries of where the discussions are at with respect to these various sections of the NMAC. Perhaps this is the point at which we actually turn to going through these sections.
Mr. Chair, if you're going to go to that place, let me just provide some advice.
May I just one point before we turn to that? I'll give you that in 1 second. I just wanted to echo Dr. Mpoma's, Commissioner Mpoma's appreciation for the parties. Obviously, I was not part of any negotiations, but many of those negotiation sessions happened in a conference room that was blocked off on my calendar. So I could tell how much time went into and how much time and effort went into these discussions. And I know they were, I trust that the parties had a vigorous debate, but also seem to have all walked away in one piece. So for which I'm very thankful to all of you. Commissioner, I'm sorry, Commission Counsel.
So, Mr. Chair, if you're going to go through section by section, I'm going to give you a series of options, but I think the best option is to focus on a statement made by the applicants. And so far, you've seemed to have found that major policy questions have sided with the applicant. The applicant said on page 2 of their findings of fact, the compromises they made represent carefully crafted accommodations that fit together as a whole and constitute a package that the OCC should adopt in full. The reason I highlight that out is if you go section by section, I think your best approach would be, is there a preponderance of evidence that supports this? And then make comments on that. I think you're going to get yourself in a more problematic situation if you think it's best to wordsmith things today. Again, as stated by the commissioners, after the rulemaking was concluded, the parties then had a series of meetings, and then they made representations at public meetings about that. As you can see from the highlighted document, every word was debated. So if the applicants had wanted to compromise on one word for one wordsmithing, they already did that. So if you believe that something is not supported by the preponderance of the evidence, then you should change it. If you think that you can wordsmith something better today, you're guaranteeing being appealed. And I know that because over a year ago, this body did a rulemaking on PFAS and left a bracket undone, and that's still in the Court of Appeals. So I think you have to be mindful that you respect the parties. The parties did try to work through the language, but we live in a day and age that if you think you can out-wordsmith this army of lawyers, you do run the risk of that being appealed. So, of course, my job here is to provide options. You can wordsmith if you like. I just think the better option would be to just look at whether that met the preponderance of the evidence, if it did or not, and not try to open your thesaurus today. Thank you.
Thank you. I appreciate that. I have a feeling that even if we didn't change a single word, that we're going to get appealed anyway. So I trust that there are many billable hours dependent on that. So, I,
But let me just add to that. So it would be cleaner to the court if you just do an up or down thing. In the Empire and Goodnight thing, you tried to split the baby and they're both appealing. Okay, the PFAFs, the winning side is also appealing. Everyone's going to appeal. So I think it's actually easier for the court if you find, and again, I don't have a stake in this, one group has met its burden, then you should just give the court a clean up and down.
Mr. Chair,
It's no help opinions.
Commissioner Pomo, go ahead.
Well, so Zach, I've read through the joint stipulation. Now, is there not also more like an option for us to look at the ones that they agree to? And then the ones that you do not agree to, and look at the alternative points that IPNM and NIMOGA provided and OCC provided. And then we can more or less come to a conclusion. But I'm not sure, from what you are saying, I'm not sure if you are saying that if we believe that this is good, we should just say it's good without really making any changes.
So, Mr. Chair, you put a pin in the word acquisition. So if you go through the rule and you're like, there is a lack of preponderance of evidence. I didn't find a compelling witness that provided substantial evidence about that term, then you should definitely change that term or get rid of it. If you think that you can come up with a different word, then I think that you're going to be here for many weeks. So I'm not saying, you have a series of options. Sure, you could say it right now. We're going to vote right now. Or you could say we want to go through line by line or section by section, talk about what evidence was substantial, how there was a preponderance of evidence. I'm giving you options, but I just think that because the parties have worked through the language so much, that you really should focus on, was there a preponderance of evidence for this, as opposed to let's come up with another verb and think that will solve the problem.
Thank you. I think we're certainly intending on reviewing, at least I am, I won't speak for other commissioners, but I'm certainly intending on reviewing on whether or not there's sufficient preponderance of the evidence to support each of the amendments that's being proposed here. And I apologize if I was flip earlier, but I think it's fair to acknowledge that this is a sufficiently large and impactful policy debate that whether or not parties feel at the end of the day that they need to take this to an appellate level and to further debate it and to review those legal decisions at a higher level, that's not within our control here. So I think we just need to make sure that we put on the record as clear as possible what our justifications and thoughts are for the series of policy choices that that the various parties have put in front of us. There are quite an extensive table of what has been agreed to and what hasn't been agreed to. And the joint stipulation, I will also just note for the record that there isn't a clear, there isn't a total consensus amongst the parties here. The only thing that NIMOGA and IPNM have agreed to is not to challenge on the basis of substantial evidence. That to me is not a particularly, so I'm not sure that I see this joint stipulation as quite as comprehensive of a wordsmith agreement and as perhaps it's being characterized. If the commission chose to adopt, in fact, I wish the parties, and while I appreciate that a lot of work went into this, I do wish the parties were able to come a little closer. In fact, I'm not quite sure how the industry, how not all industry, because OCC, I appreciate you guys having I appreciate that OCC has moved in their position, but IPNM and NIMOGA in agreeing not to challenge only on the issue of substantial evidence. That seems like I'm not sure that that makes any difference for the commission, whether or not we adopt the applicant's original proposal or the applicant's amended proposal. Either way, NAMOGA and IPNM aren't going to have a substantial basis as a substantial evidence as the basis of an appeal. So I'm not quite sure that we have as much of an agreement in front of us that we could simply adopt wholesale without going through and reviewing the points of contentions that remain. And I certainly, to the extent that various portions have not been agreed to by IPNM and NAMOGA, it's my hope that we can at least build out a more substantive record for any higher court as to why we chose one proposal as opposed to the other. Understanding, of course, and I take the commission council, I take council's point fully that these provisions are interrelated and that we need to be very, very, very cautious in how, if we were to adopt any changes at all, how those might interact with other provisions.
Mr. Chair, from my point of view, I believe that the joint stipulation is really great in the sense that, let's say in areas where NAMOGA has different thoughts, they provided some options. So we will look at it. I think our job will be to come up with the best or the great rule that we could do based on the hearing that went on. And whatever happens, probably, we'll see. But I think we have obligation to look at what is in front of us and see what we can make out best out of it. And the legal stuff, the lawyers will take care of it. Thank you.
One thing that might determine, Mr. Chair, how we move on would be just an overall sense of, are we in agreement as a commission on the joint stipulation, or are there aspects of it that we have concerns about and want to discuss further? I have a few things we could run through those, but and other people in both of your concerns, if you have any, and see where that takes us as we go through the rules too. So a few different ways to proceed. And Mr. Chandler, I do understand the general thrust of what you're saying and where you're going, and that in a sense we're also fortunate to have an agreed upon joint stipulation in front of us. And that's fortunate in many ways. So thank you for your comments there.
Okay, so turning to the issue right in front of us, which is should we proceed to the rest of the issues as teed up following the hearing officer's guide, or would the commission like to turn to perhaps Exhibit 89A of the joint stipulation and go through that in that order?
Yeah, Mr. Chair, I'll suggest that we go through the joint stipulation. We take them one after the other, and then also try to look at the summary table that was provided to us, because that will give us a sense as to where we are. Yeah, thank you. Of course.
And Mr. Chair, I think it's generally one and the same to go through, either the hearing officer's report. I mean, she tells us what the definitions are that we're going to discuss. If we actually just turn to 89A and go through those, we can do that. And then I know there was the side-by-side sort of spreadsheet of changes, but I think
The table, yeah.
that table, but that table only contains things that were agreed to between the parties. It does not include all the new definitions that were put forth. So
Yeah,
should probably go through 89A.
So I was saying we go through 89A, but we can cross-check that table.
Yes.
Yeah, very good, Dr. Mpama.
Okay.
And perhaps the first order of business might be a 10-minute break.
I was just about to suggest that. I appreciate that. Why don't we take a quick recess? And let's see what the current time is. Why don't we return at, is it 10:06 or 10:06? Is 10:15 a good time? All right, let's do that. Thank you all. All right, calling this meeting back to order. Oil Conservation Commission, still the morning of June 3rd. Right before we had a recess, we had discussed going in and reviewing the Exhibit 89A and going through the post-hearing proposed amendments section by section. I believe actually the commissioners wanted to revisit the motion to exclude before we proceed further. So if that's the commission's desire, I'm happy to entertain that and take that up and resolve that motion before we proceed. Is that what the commission would like to do?
Yes.
In that case, I will turn to the WELC motion to exclude. So the motion was filed on May 6th, if I recall correctly. There was a reply on the 21st. Is that correct? I mean, a response on the 21st and a reply on June 1st. Okay. I'll open the floor to commissioners on that motion.
Dr. Mpoma, go ahead.
No, Mr. Chair, thank you, and I appreciate the time for me to at least go back and then revisit this issue. I've read through it, and I will say that, even if you look at the timeline, that evidence came in after the closing of the record. And even if you look at all the subsequent replies and all of that, so after reading through it, I sided with the applicant that we should exclude this. Thank you.
Commissioner Bloom?
Mr. Chair, I have to admit, I was not aware of the June 1st filing until this morning. But looking at that, I think what is determinative for me in large part is the notice itself, which is reprinted in the applicant's final reply here on June 1st. Which says, if the evidentiary hearing closes before any of these dates, public comments will no longer be taken and a translator will not be available. And then some additional language. Any person may submit written comments on the proposed amendments no later than 5 p.m. on the final day of the evidentiary hearing. The document from the entity, the association, we're discussing came in after that, and so I would also support that that this public comment is excluded because it arrived too late.
I don't have a strong feeling on this one either way, but it sounds like if commissioners are ready to make that decision, I will entertain a motion.
Mr. Chair, I would so move, and I guess we should also say that because we are excluding Exhibit 7, we would also exclude the related findings of fact, of which I believe there was one, number 88, and then I think also IP&M number 191. So we would exclude those as well. I so move.
Mr. Chair, I second.
Any votes opposed? Okay, so the applicant's motion is granted without opposition. Okay. Thank you. In that case, I will turn to, let's see, we were going to have have Exhibit 89A as for organizing our deliberations around, since that is the applicant's post-hearing proposed amendments as submitted with the joint stipulation. Is there, so I'll ask commissioners to help me here since nothing is, well, since I'm just going to go through and look at stuff that's underlined. So if I miss anything, please bring it to my attention. Starting with NMAC 1915-2, the first proposed amendments is in section A, A13. Is there any debate on that? And feel free to say no if there isn't any.
Yeah, Mr. Chair, no, and generally, I think these definitions, well, I don't know, I don't know how we're gonna go about this actually and have our discussions. I mean, I guess if we had, for example, issues with some of the treatment of temporary abandonment, perhaps we would follow this through and raise that in subsequent sections. But here, for me, this definition certainly works. And I guess we could keep going through these and
No objections at this time.
no
at least.
objections, yes.
Okay. Can I clarify? I know that I wasn't planning on opening this to all the parties and creating too much chaos, but it would be helpful if perhaps parties could help me understand this changes that did not make it into the table reflecting the negotiated language. Does that mean this was unanimous? So taking, for example, the temporary abandonment change here that's not reflected on this table. So, okay.
Now I think we
There's
have,
no
I think we have
agreement, right?
confusion.
Yeah, okay.
No agreement. So.
Okay. No agreement either. So, and therefore no negotiations occurred on this? Because I'm just trying to figure out what made it onto the table versus what didn't make it onto the table. I'll invite anybody to weigh in here.
Mr. Chair, members of the commission, good morning. Thank you for the work that you're doing. I'd say we negotiated practically every provision we had negotiations on, and the extent to which there's agreement, is reflected in the joint stipulation, and the extent to which there's disagreement is reflected in NMOGA and IPAM's proposed rules to you all. And as the chair noted, there wasn't a great deal of substantive agreement between ourselves, OCD, OCC on the one hand, and IPAM and NMOGA on the other in terms of, the final language, except to the extent that there's the waiver to challenge based on substantial evidence.
And Ms. Fox, if you could identify yourself for the
Apologies. I'm Tanis Fox, lawyer with Western Environmental Law Center, representing applicants in this matter.
And this is Miguel Suazo with Beatty and Wozniak appearing today on behalf of NMOGA. I think just to clarify, if it's not on the table, that indicates there's no agreement.
Okay. Amongst any of the parties, right?
Correct.
Okay, got it.
Mr. Chair, well, no agreement between applicants, OCD, OCC on the one hand, and IPAM and NMOGA on the other.
Got it.
Thank you.
Thank you. Does that capture it? No other party wants to object to either of those characterizations? Okay, thank you. Okay, so I will continue on then. So far, no objections at this time from or no concerns from Commission Council on the temporary abandonment language. Commissioner?
Oh, okay. Yeah, so the way I look at it, so I try to compare what the applicant OCD is saying to the other parties.
Mhm.
Now, on this one, it sounds like only NMOGA is the one that wants to strike out the temporary abandonment or temporary abandonment status. Now, IPNM agreed to that. OCC agreed to that because at least they did not really, they did not make any comment on that. So I will say that it doesn't change anything because if you look at the definition, it still means the status of the well that is inactive. So I do not have any objection leaving this provision in the rule. Thank you.
And Mr. Chair, yes, I would add in this case that I find those words to be supportive of changes that are made further on in this document, in the rulemaking, and that as we move into that there's adequate support on the record from the applicants, OCD, to support that at a minimum.
Okay. You're finding that there's sufficient evidence in the record to support the change as proposed in or this proposed change.
That
Is
is
that correct?
correct. And I would generally say that that holds for, unless I disagree with something explicitly, that I believe that there's support in the record for the proposed changes and the agreed to stipulated changes as well.
Okay. Any debate or any concerns about the next change then? B5, barrel of oil equivalent.
No, Mr. Chair.
I'm not going to go through the renumbering of the automatic renumbering because unless there's any objections from commissioners, I'm going to assume that there's sufficient evidence in the record for renumbering of sections. The next then is B7. Any objections, concerns, or any concerns or objections? Beneficial purposes or beneficial use.
Mr. Chair, I think I understood where the applicants were trying to go with the inclusion of language around speculative purposes, but there was an agreement to strike that, and I am supportive of that. It was a difficult, I don't know if notion's the right word, but a difficult addition in some ways. So I can understand why it was struck, given the concern we heard about it from all the parties, or at least from the industry parties.
Mr. Chair, so if we go to the table, that'll be the first one. That'll be on page 1.
Page 1, isn't it?
Yeah, the page 1 of the table. Now, all parties agree, most of the parties agree to the joint stipulation, but NIMOGA is proposing something addition to this. Now, and I want to address that. So NIMOGA is saying that include but not limited to production, injection, monitoring, which is the original, or let's say that is the one that was agreed to, or more or less, that is the original language in what we are looking at. So NIMOGA says that oil, move on to say that we should add enhanced oil recovery. Now, from my point, that also falls under production and injection, monitoring, water flood, injection. And even you can add production to it. Regulatory compliance. So that is the one that that does not, but even that one, so that one is a little bit tricky because I do not see how that falls under that 3 categories. So my question to my 2 commissioners is most of the things that NIMOGA is proposing here more or less falls under the production, injection, and monitoring, but the regulatory compliance, that is the one that is not part of the current definition that we have. So I don't know if you have any thoughts about that.
Commissioner Bloom?
Dr. Papa, what's the word you're suggesting adding there?
So NIMOGA is suggesting that we do add multiple terms, but in there, I'm able to relate all those terms to the I'm able to relate those terms to either production, injection, or monitoring, except the regulatory compliance. That one I do not. So that is the one that does not fall under the production, injection, and monitoring. So I'm asking, do you have any objection adding that to the definition?
Commissioner Poma, would not enhanced oil recovery, EOR, and water flood operations be included between production and injection?
Yes.
That is what I said.
Yeah, okay.
Yeah.
And then, so now you're thinking adding regulatory compliance in there?
So that's the one that I cannot really put under production, injection, or monitoring.
But what exhibit or what person persuaded you that this term regulatory fits within beneficial purposes?
So Commission Counsel, during the discussion, I think the main thing was about the speculative purposes, and almost all the witnesses that from both sides more or less touched on this issue. And we started talking about the examples. And most of these that Nimoga is listing here are all examples that were presented to the commission. And when I look at it, I can really relate each of them. One thing that we did not get the opportunity, even we asked, let me put it this way, we asked about if we take out the speculative purposes, does that change the definition? It does not, based on the discussions that we had. But these examples that have been provided, I know we discussed most of them during the hearing. So I'm just asking the the other commissioners, if we add a regulatory compliance, does it change anything? Now, I can tell you that taking out the speculative purposes more or less ends everything. But I do not know, mostly from OCD point of view, the regulatory compliance. That one, I cannot really put that under any of these three. But without that, this definition is still complete. It gives OCD more room to be able to even take consideration of what Nimoga is listing here. So it doesn't really change anything. If we decide that, let's keep this one, it doesn't change much here.
What jumps to my mind, at least when it comes to a well being used for regulatory compliance, if it is not otherwise being used for beneficial purpose, is typically what I would think of as monitoring, right? Groundwater monitoring of, so, but I also am trying to be mindful of what other regulatory compliance needs may or may not arise that is not related to monitoring. I can't say that that's not possible, but I guess I would have to think a little harder on that. Do you have any thoughts?
That was my question exactly, Mr. Chair. And I would also wonder if we added that, if later it could become some sort of a wide open door loophole in a sense that it could be used to keep wells not bonded longer, if there was some sort of compliance agreement struck. And we've seen some pretty beefy regulatory compliance movements at times. So that would give me pause as well. I don't know if either of you know of any point in the record that addresses what this addition of regulatory compliance gets at otherwise.
I couldn't tell you. I couldn't tell you the specific transcript point in the, but I think I'm with Dr. Mpoma that I do recall at least monitoring wells being mentioned as a potential beneficial use. But and presumably monitoring could be done for the purposes of regulatory compliance, but I couldn't tell you off the top of my head which witness or what point in the transcript that may or may not have happened.
So, Mr. Chair, my advice would be to pull up on your computers both the applicant's proposed findings of fact, and then in this case, it's the oil and gas. If they've done their research, they will give you the exact, you can just find that word, find that sentence, and they will tell you who said what. And if they didn't, then there isn't a preponderance of evidence.
Fair enough.
So that would be in Nimoga's closing brief.
And so, yeah, Mr. Chandler, commissioners. Okay. I mentioned in two spots here. One is 78 on page 66. Nimoga is closing as reference of it. Does not give an explanation of why regulatory compliance should be added. And then neither does the second treatment of this on page 75.
What finding number is that? It's 3.
So under fee conclusion and request for relief, we just see, so I'm just searching the PDF here and finding broaden the definition of beneficial use in active wells to include regulatory compliance, among other things. So, unfortunately, I don't see anything in the record here which would tell us why we would want to add regulatory compliance to production, injection, and monitoring.
What was the previous one of 2?
0.78 on page 66.
And Commissioner Bloom, so let me say that, I just really wanted us to discuss that, but let me say that without even adding those, I believe that the production, injection, and monitoring in our oil and gas business more or less covers almost all the operations that you can think of. But I was just not sure about the regulatory compliance. So if we have to leave it as it is now, let's say they've negotiated and sound like some agreements are there, it doesn't change the definition. It doesn't change the definition. If we are to exclude the regulatory compliance, it doesn't change anything. Thank you.
Mr. Chair, I'm not sure what it would change if it was in there. So not having seen discussion of it elsewhere, I would not support adding those words.
Perhaps we can phrase it this way, that the commission finds that the proposed, that between the applicant's proposed language for this provision, for this definition, and the modifications proposed by NMOGA, the commission finds that there is more substantial evidence to support the applicant's proposed definition.
I would agree with that, Mr. Chair.
Yeah, that's correct. Thank you.
Okay. Is this sufficient for the record, Commission Counsel, or would you, when there are issues like this, would it be better for us to formally take a vote on it?
Mr. Chair, that's sufficient.
Very good. In that case, in that case, I will move the discussion along to EF, subsection EF. No, I'm sorry, E8, expired temporary abandonment. Any discussions on this?
Yes, Mr. Chair. So here I would note that the joint stipulation does not speak on this. NMOGA's position would be to not include this newly proposed definition. This is a point where I would raise a concern raised by NMOGA, which allow me to get to that. So I have about 5 different windows open here. Page 11 of NMOGA's closing, they state the commission lacks authority to remove the 2-year temporarily abandoned well threshold for heightened and active well assurance. So if we look at 7214 again, 770-2-14 for the record. We look at the last sentence there. It says the Oil Conservation Division shall require a 1-well financial assurance on any well that has been held in a temporarily abandoned status for more than 2 years or the election of the operator may allow an operator to increase its blanket plugging financial assurance to cover wells held in temporarily abandoned status. So what this is doing is giving the operator with a well that's entering its first 2-year period, a grace period to go unbonded. And Amoga is saying that to take away that grace period would be inappropriate and outside our authority because of what we see here in statute in 70-2-14. That makes sense? The concern?
What is your, I guess, what is your take on that concern, I suppose? Or what is your view or analysis or opinion?
So if I could weigh in, the hearing officer framed it that you made these major decisions. So you've already made a major decision, 70-14. The applicants have proposed something that you have legal authority over. So whenever something comes up about, is there legal authority? You've already answered that policy question. So if that's what you're hung up on, then I'd advise, if you believe you've already decided there's legal authority, then you accept the proposal.
Mr. Chandler, thank you. And here's what I've been thinking on this. Says the Oil Conservation Division shall require a one well financial assurance on any well that has been held in a temporarily abandoned status for more than 2 years. I believe that 70-2-14, for the reasons I expressed earlier in the day, gives the OCC the ability and the latitude to create new financial assurances. And this would simply be a new financial assurance that is required during that first 2-year period. And I would be comfortable with that. I wanted to discuss this and put it on the record. That's why I raised it. Thank you.
For sure. Commissioner Mpoma, any thoughts?
Yeah, on this one, I do not have much thoughts on this. So based on what Commissioner Bloom is saying, and based on the discussions, I do not have, just to say, I do not have any thoughts about, let's say, taking this off. So I do not have any reason to take this off. Let me put it that way. Thank you.
I think I agree with Commission Counsel's advice and Commissioner Bloom here that the proposed change here is supported and within our statutory authority. So without objection, doesn't seem like the commission is comfortable with this particular proposed change to subsection 8.
Yes, Mr. Chair.
Yes, Mr. Chair.
Great. In that case, section I-4, inactive well. And this one, there was some negotiation, or at least some outcome of a negotiation on this particular
There
definition.
was negotiation, and we come back to the same discussion we had just a moment ago about potentially including the words regulatory compliance. Again, NMOGA would pull over that suggestion here. But for the reasons that we discussed previously, I would reject that and not include the words regulatory compliance or the other NMOGA proposed additions.
I agree with that. Thank you.
Okay, so if the commission agrees, I will have the record reflect that the commission finds the negotiated language in the applicant's final proposed rule to be better supported than the modification language recommended by the Oil and Gas Association.
Very good.
Is that fair to you, Commissioner Mpoma?
Yes.
Then we go to, let's see, L6, low producing well. Also another term that was negotiated, if I recall correctly.
Yes, I'm supportive of this definition of low producing well.
This definition is similar to the marginal wells that was discussed extensively. And I'm glad that at least all the parties got together to change that marginal well definition. Because EPA do have a definition for that. Other states do have a definition for that. So it becomes a little bit confusing. So I'm really in support of low producing well. Thank you.
Commission, any further comments?
No, Mr. Chair.
Okay. So commission finds that this, for L6, that the language as proposed in the final stipulated, joint stipulated, proposal is well supported and should be adopted. Yes?
Yes.
Yes.
The next issue, I've got M2 being struck out.
Yes, as Commissioner Mpoma said, Mr. Chair, we are striking the proposed definition of marginal well, which was replaced up above by low producing well. I believe we just discussed that and have full support there.
Okay. So without objection, commission concurs. The next change for us to review is still in 1915-2, but now in section or subsection T, and it looks like T3 is being struck.
Yes, Mr. Chair, and I would note that in NMOGA's draft, they would retain that. This language was actually, if we go back up to A, what was added in there next to the definition of approved temporary abandonment, the words temporary abandonment or temporarily abandoned status are added in. So it's really about where those words appear, Mr. Chair, and I'm supportive of them appearing above under A and striking in T.
Okay. Any objections to that modification?
No.
Okay, without objection, so approved or adopted. Okay, I'm not seeing any further changes to 1915-2. Did I miss anything, commissioners?
I believe we covered it.
Okay. Great.
Mr. Chandler, would it be helpful if we voted on passage as suggested in the joint stipulation, or was the fact that we went through and approved each definition sufficient for you?
Mr. Chair, what you've done is sufficient. I thought you were going to say you're going to take a vote on this section.
Happy to.
If you want to do that, or if you want to do a final vote, but what you've done so far has satisfied me.
Okay. For commissioners' formality's sake, I'm totally fine. It doesn't, if I recall correctly, we didn't make any amendments from the bench here, right? So if the commissioners would like to make a motion to adopt the proposed change, the specific changes to 1915-2, I'm happy to entertain that motion.
Mr. Chair, I would make that motion and just note that this is to the applicant's exhibit 89-A for the record, which is part of their closing statement.
Second.
Any votes opposed? Any objections? Without objection, so adopted. Okay. Turning to 1915-5 NMAC. The first proposed changes that I'm seeing is 1915-5-9, A4 and 5. Or, yes, A4 and 5.
Mr. Chair, so on this one, the parties did agreed on most of this, and neither party opposed to this. So I do not have any modifications to this. Thank you.
Mr. Chair, Dr. Mpoma, I believe if we look at the final proposal from Nemoga, they actually propose an alternative here. Excuse me. Which would, I think, simply strikes the proposed applicant's treatment of this section and leaves it unchanged. Let me get to the second page here. Yes. So really it's deciding between the joint stipulation and what Nemoga has put forth.
Um, I don't have my computer open at the moment. I'm trying to juggle too many paper documents. For my fellow commissioners who might have this handy, would you like to refresh for the record and for my recollection, the respective proposed findings of fact that would support or justify the alternatives in front of us today?
Yes, Mr. Chair, give me a moment here. I am just pulling up some other documents. Thank you.
Apologies to the audience who I'm sure are wishing they could watch this thing on fast forward.
So, Mr. Chair, what's happening here is we are bringing some new aspects of compliance to bear, and I think we'll get more into this as we get further down in the rules. So we're in 1915-5 right now, and we'll see what those requirements are when we get down to 1915-27.8 A through D. We'll have those requirements. So this is an expansion and part of the overall plan of the applicants to bring more wells under bonding when there are circumstances that should require it.
This is where the interconnected nature of these sections become challenging.
And if we want to move down there, I'm looking at the applicant's closing. We could go to page 115 of that, and I could make a note here, and we can pull up 8 A through D. Second. So we go down to 1915-25. 8. I want to make sure we got the citation right there. I'm wondering if we're actually looking at if that reference shouldn't be to 1915-27.9 D, because that's where there's no, only A to B 25, 27.8. So let me cross-check these references here.
Yeah, I do have a comment, if I may.
Commissioner, please.
Yeah,
Yes, Dr.
so,
Bond, I don't know if you see this too. But
yeah, so the way I look at this, remember during the hearing, I mean, this provision is where Nimoga was saying that if one company, let's say, vents one, so let's say they have the vent or flare, one, what that means is that more or less this provision will more or less be applicable to them. But if you look at what the stipulated agreement is, to me, it's so clear because it's saying that subject to an agreed compliance or final order setting a schedule for bringing the wells into compliance with 19.15.25.8 NMAC and imposing sanctions if the schedule is not met. So what Nimoga is saying is that we should be a little bit lenient here and say that if, let's say, 2 wells or 50% of wells operating in this doesn't meet that, so that, to me, that's a little bit of a loophole. So we should more or less look at that from that sense. During the hearing, I mean, the applicant opposed to that. So that is how I see it. So let's say if 5 wells, if the operator operates between 110 or 101 and 500 wells. So if 5 wells are not in compliance, or let's say did not address the compliance order, they should still be good. That is a loophole.
And Mr. Chair, I'm still trying to determine if the cross through the citation to 27.8 is right, or if that should be 27.9.
Commissioners, and Tripp has her hand raised. I don't know if she can help with this or.
I apologize. We're not monitoring these screens very closely, but sure, I'll entertain a comment from Ms. Tripp. Oh, sorry, my turn to not have my microphone on.
Thank you, commissioners, and I apologize. I'm not sure if this is the appropriate forum, and I invite any of the council there to correct me. But under 5.9A4, and I may have misheard, but it sounded like there was a conclusion or interpretation that all the parties were agreed to that change. And I wanted to clarify that I do not believe IPNM or NMOGA agreed to 4A through D. The only language agreed to is highlighted in blue for Exhibit 89B.
I think yes, I think we're on the same page, but so the highlighted language is agreed to with reservations, but there's other language that's not highlighted that would be where there is no agreement amongst the, yeah. Okay.
Yes, that's correct. Thank you.
So, Mr. Chair, I don't know if you're following this too, or if the other commissioners are concerned. I mean, is this a proper citation to 27.8? If we go there, there's no A through D.
I'm afraid I can't help with that at the moment because I don't have a computer that's proper.
Because there's,
You can also want to cross-reference and pull up the NMAC as it exists today. Wait, you're in 1915, 25 and not 27. This is 27.
27.
I think you might have to
Yep.
pull up
Thank
the
you.
actual NMAC.
Now I need to go down 2 sections. Thank you.
Right. Have you found that? So first of all, let's just make sure
Okay.
we're on the same page as
Yeah, that's correct. That works.
okay.
yeah.
So now going back to my earlier question, have commissioners been able to pull up the respective findings of fact? Because there is a disagreement between the parties on this section, and I'd like to review the findings of fact, the respective proposed findings of fact on the record.
Almost there, Mr. Chair. Hold on. Yes, I was looking through the crosswalking to 1915, 25.8 there. That appears to be appropriate. And generally what we're doing here is refining some of the aspects of compliance and the wells, number of wells, which would be required to be bonded. Generally, we saw significant testimony on this and its impacts on the bonding regime the state would have after this. And generally, I think this is gone over extensively in the applicant's closing and that there's strong support for it.
Okay. Just for the record, is there a specific finding number in each of these briefs that we can point to? I can also turn to the parties and see if they can help us out with organization.
So, Mr. Chair, on the applicant's proposed findings, it looks like 79 through 88 provides the preponderance of the evidence to support the proposed language.
79 through 88, is that what?
Yes.
Thank you. Okay. And just for the record, perhaps Mrs. Swazo, you can help us with, do you have the numbered paragraphs for your proposed findings of facts for the
Yes, I can assist. Apologies. I normally have 3 or 4 screens, so it's harder to navigate this one. Should be on page 21 of Namoga's closing brief. Finding of fact 72.
could you repeat that? My apologies.
Yes, it's Namoga's finding of facts 72 through 74.
Page 64. Yeah.
Here. No, that's not, yeah, that's not this. Fine.
The one that we.
Hang on, let me,
The one I have is in alphabets. Alphabets, I believe.
Could you clarify for us again? I'm sorry, which document you're in? I'm running out of fingers here to bookmark pages, but
sorry, I am too. It's in our closing brief, page 21, finding of fact 72 through 74. We also address in our legal arguments on page 21.
so page 60, no.
I'm looking at the Namoga's closing, page 64.
You've got bullets on, but you've got bullets on page 21. Is that the two paragraphs you want us to look at?
Hang on, let me confirm. I'm not sure I have the right document.
So what I would suggest is maybe a 5-minute break. And let's have Sheila print all this out. Still we need the computers because that is still the fines function, but it might be productive that everyone has the 3 major ones so they can leaf through. Is that an acceptable 5-minute break if we could do that?
Yes.
That certainly works for me if
Might
commissioners.
be closer to 15
15.
minutes for Sheila to get upstairs and print a few things out.
Yeah. That's fine by me. I do want to make sure that we give fair consideration and thorough consideration to all the parties. So I appreciate all of your patience as we make sure that we dot our i's and cross our t's and review each finding of fact with each proposed change here. So with that, let's take let me find the time here.
Back at 11:30, it's
Well,
11:15 right now.
Let's plan on meeting back here around 11:30. Thank you all. I'll call a recess.
It's kindergarten.
If
I
I-
have one thing before we jump. Back from the recess, I got something.
If I could bring the meeting back to order real briefly from the recess. Commissioner Bloom, did you have something for the group?
Yeah, Mr. Chair, thank you. Thanks everyone for that pause. Oh, Sheila, can you all hear me okay on this? I don't know if it's been picking me up. It sounds kind of weak. Just as kind of a procedural matter as we're going through this, generally I've done rulemaking in the past. We'll go through, and if there's a difference of opinion or a concern about a change that's being made, we can bring those things up and hash through that based on the evidence we found in the record. But I think if we try to go through and look for findings of fact for every single edition, we're going to be here for weeks and comparing them across multiple parties' closings. So I certainly didn't come prepared for that, as you saw from the last half hour. I don't think any of us have. I think we put a good bit of time into looking at the questions, the bigger questions about statutory authority, many of the things that the hearing officer put in her report for us, and we got through those. But I think just going forward, for me, what makes most sense is going through, seeing whether there's agreement, disagreement, hashing out disagreement, voting, and moving through this. And then, at the end, we can talk about what our findings of facts are, specifically and generally. So I don't know if that would work for the other commissioners.
Commissioner Bloom, I thought that, the chair wanted us to at least cross-check what each party was saying about this particular issue to guide us with our votes. I do not have any problem with that, because at least that shows that we are actually doing more due diligence to make sure that we make the right decisions based on the facts. So I do not have any problems trying to go back and forth to make sure that we are in agreement, especially if there is opposition to what the applicant is presenting, and then even the joint stipulation is also saying, it's better we cross-check. And I'm pretty sure in the past, I believe that Felicia is going to help us a lot to direct us straight away, go to this page to really speed up.
I think we're all saying slight variations of the same thing. I know going through that there are differences of opinions between the parties on certain sections, and I'm certainly not necessarily trying to belabor and get into the pedantic of each. I don't want to belabor it to the point of being pedantic, but to the extent that this commission is being called on to make a decision between alternatives that have been presented, I just want to make sure that the commission feels like it's had an opportunity to articulate what it's relying on and why the commission is choosing one particular choice as opposed to the other on this menu of options that the parties have asked us to consider.
Sure, Mr. Chair, and just for me, kind of big picture, I feel like the homework, prior to coming here was comparing the various arguments and closing arguments versus actually doing that here at the dais for hours on end, comparing one to another. I think we have, I think each of us has an idea of where this is going. I don't know where y'all are coming in or what issues you might have here. And clearly I'm comfortable with a lot of the applicants application here. And so that makes a sensible starting point to do a comparison. And if there's things that I have issues with, and there have been some, I think I brought up the issue that Namoga raised about first 2 years of TA status and require a new bond for that. we kind of talked through it. Y'all didn't have issues with it. We moved past it. Those sorts of things. So I'm going to bring up things that I have issues with, but I'm not necessarily going to sit here and engage in, every single line, comparing every red line, everything that's in blue versus multiple parties, closing arguments and statements, this afternoon. But if y'all need to do that, I'm certainly here for the ride. So we'll get through it. But I didn't come prepared to sit here and look at multiple applications side by side. I did that over the past weekends when I carved out time to do this work. So thank you.
Understood. And we'll try to do this with, we'll try to build as full of a record as we can while being as minimally pedantic as possible. Okay. I think our commissioner clerk needed a little bit more time to print and resolve some just to get us organized with some paperwork up on the dais and noting the hour. I'm going to recommend that we take an early lunch and reconvene. Let's see, at 1 o'clock. Would that be acceptable to commissioners?
Very good, Mr. Chair. Thank you.
Okay. So with that, let's take a recess and lunch recess until 1. Thank you.